Lou to turn. And they'll be available on the
Yeah, that's,
First Church website
if you want to make
in a
it
day or
smaller,
two.
you can.
That, and you're welcome to view some that you've already seen, or any that you missed. For those in the room, the important message is if you need to use a restroom, they're straight down the hallway on the left side. So without further ado, let me say thank you to my friend and colleague, Alan Weiner. We were together at the State Department, where he was in the legal advisor's office, for coming to the Stanford Law School as a senior lecturer. His specialty is international law. He has worked on and with, I guess is the word, the International Criminal Court, and actually does war crimes activities as opposed to simply studying it as an academic. So without further ado, Alan, thank you. It's for 45, 50 minutes as you feel comfortable, and then we'll open up to questions both here and in Zoom land. So thank you.
Okay, super. Thank you, Tom, for the introduction. As Tom says, he and I have known one another for many years. I will confess that I was a junior lawyer when Tom was already an assistant secretary in the State Department. When Tom says that I do war crimes issues, I want to state for the record that I don't actually perpetrate war crimes.
So I guess this guy is talking, but I can't.
Okay, I hear a voice in Zoom saying that somebody can't hear me, which suggests they may have a problem with their own device.
Please mute yourself. Here, and you can close that. Whoops, just that's a hot corner. So there you go. And then over here. Got it.
Okay.
I've been hearing Ellen just fine.
Okay, well, let's proceed then. So the topic that I'm here to discuss with you are war crimes, and what are they and how can they be prosecuted? I think some of you may have had a chance to review an excellent article by Francine Hirsch that provides some background to that, but if not, that's okay. We'll kind of provide a little tour d'horizon of this subject. Now, when we talk about war crimes, of course, we're talking about crimes that are crimes under international law. But to understand the significance of that, before we dig into what war crimes are, it requires me to provide a very brief overview for you of what international law is, for those of you who are not international lawyers, and more importantly, how the international legal system works. I think that's going to be quite important for us to understand what war crimes are and how they can be prosecuted. So I've got a few slides I'll show. When I teach my international law class to my students, I provide them with this definition from my casebook of what international law is. It's the system of rules, lawmaking procedures, and institutions that regulate relations between states in the international system. The key here is that international law is focused on relationships between states. If we think of our own legal system as a system that regulates the relations between us as individuals, as the persons in the legal system, and maybe some other entities that qualify as persons like partnerships or corporations, the legal system in the United States is the legal system that regulates relations between us. In international law, states are the persons who are regulated by the legal system, and that's essentially what international law is. Now, international law, though, is a quite immature legal system in comparison to what we might be used to in a well-functioning domestic legal system. There's no global government that stands in a position of authority over states. States are essentially both the subjects of international law, the persons who are regulated by international law, but they're also the legislators, the ones who make the rules. International law is, for the most part, a consent-based system, both with respect to the substantive legal rules that apply, what rules will states be bound by, but also with respect to the institutions that they're going to take part in and be subject to. And for our purposes this evening, that will include which international courts they will accept the jurisdiction of. So the absence of a global government, of a world government, means there's no compulsory system. There are no courts to which any country can necessarily bring any complaint against any other country. Now, that can be misleading because, of course, states have consented to the jurisdiction of international courts, and they do participate in a tremendous amount of litigation internationally. And there are international criminal courts, as we'll see, right? But the point is that there is no general system of third-party dispute resolution that can ensure that any state can be brought before a court if a dispute arises. And there are also no global institutions for necessarily enforcing the law, in the sense that there's no international police force. The UN Security Council has the authority to impose measures, sanctions on states that don't comply with decisions that the Security Council may have adopted or may have enacted. For instance, when Iraq invaded Kuwait, the Security Council imposed very severe sanctions on Iraq and eventually authorized states to use force to compel Iraq to comply with the Security Council's demands that Iraq withdraw from Kuwait. But of course, the Security Council cannot act against the wishes of any of the 5 permanent members of the Council: Russia, China, the United States, France, and the United Kingdom, each of which has what is known as the veto. There's no actual official veto, there's no stamp, but under the rules of the UN Charter, decisions of the Security Council on substantive matters require 9 votes of the 15 members, including the concurring votes of each of the 5 permanent members, right? Which means that the Security Council will not, as we have seen in the context of Russia's invasion of Ukraine, right? The Security Council will not be available to adopt compulsory measures, right, if the interests of one of the permanent members or their close allies are affected. Much of the enforcement of international law is done through what we refer to as horizontal enforcement, right, or self-help. Whether we're dealing, it's horizontal in the sense that we don't have an authority in a position of superiority that is enforcing the law against subjects, but rather members of the international community, the persons of the international legal system, are enforcing their rights directly against one another. And of course, we've seen that in the context of the Russian invasion of Ukraine, as we've seen the United States and many other states have adopted very, very severe sanctions against Russia as their way of trying to enforce the prohibition against the unlawful use of force, the illegal aggression that Russia has perpetrated in Ukraine. So that is my, again, very, very brief overview of international law and the international legal system. But it is, again, it's worth bearing in mind because we often will, when we talk about international law, we'll often hear frustration about the limits of the ability of the international community to respond to illegal action. And that is because of this essential inherent character of the international legal system, its consent-based foundations. Okay, so let's now turn a little bit to war crimes. That's the subject of our talk today, not international law generally, although, of course, always happy to talk about international law generally. I'd like to talk to what we colloquially refer to as war crimes. And so what are they? Now, when I answer that question, I'm going to briefly contradict myself. What I just told you that the international legal system concerns relations between states. And that is essentially true. But even though international law regulates the relationship between states, not person, the law has done 2 things in connection with the status of individuals. Number 1, international law has begun to confer rights upon individuals. This is the whole human rights movement, right, in which individuals have rights not against even their own governments, right, as a matter of international human rights law, a movement that really began largely with the post-World War II era and the Universal Declaration of Human Rights. And perhaps as a corollary to the notion that international law has begun to recognize rights of individuals, and again, it's important to recall that states are the legislators. It is states that determine what rights individuals will have in the form of international human rights. But as a corollary to this notion that individuals now have begun to acquire rights under international law has begun to confer duties on individuals and to provide, if they violate those duties, if individuals violate those duties, they can be held criminally accountable for violations of international law. Now, this is a relatively novel phenomenon. There is ancient, maybe examples of it under the law of piracy, but really, and there is some old law of war, treatment and mistreatment of prisoners, but really this notion that individuals could be held criminally responsible for violations of international law, I think is linked most famously to the tribunals that were established after World War II, the Nuremberg Tribunal and the Tokyo Tribunal. And at this time, the notion that individuals could be criminally tried for violating obligations under international law was a quite novel phenomenon. Now, what was the basis for doing this? On what basis did we decide that individuals could be held responsible rather than simply the states that they were officials of? And the Nuremberg Tribunal said something like this. Well, it said something exactly like this. It said that crimes against international law are committed by men, not by abstract entities, and that only by punishing the individuals who commit such crimes can the provisions of international law be enforced. Now, this is surely a bit problematic, because this would be true of every violation of international law. Every violation of international law is committed by an individual, a man or a woman who's in some position of authority in government, and it certainly is not the case that we recognize criminal responsibility for every violation of international law. If it turns out, for instance, that President Biden's a policy of banning TikTok on federal information systems, if that was deemed to violate U.S. obligations under our trade commitments, it surely would not be the case that President Biden could be criminally tried for violating the rights of ByteDance or China. Exactly which violations of international law will give rise to international criminal responsibility is a subject that we can talk about more if you decide to. If you're so inspired by this talk that you decide it's not too late to come and come to law school, then you can take my international law class and we can explore it there. But for now, let's just say that a certain category of violations have been deemed to give rise to individual criminal responsibility. And what I'll do now is talk about what those offenses or what those crimes are. So turn now, the principal category of international crimes, again, that emerged from the Second World War, from Nuremberg and Tokyo, they're colloquially, as I said, we often refer to them as war crimes. In fact, this talk is called War Crimes, right? The truth is, it's actually not always a requirement for there to be individual criminal responsibility, for there to be an individual crime that have taken place in the context of war. In fact, the discerning international lawyer refers to this category of offenses as serious violations of international humanitarian law. Right? We'll use war crimes as a shorthand during the course of our talk today, but I need to stress we need not necessarily see a state of war for there to be a serious violation of international humanitarian law. What is distinctive about those crimes, what makes them international crimes, is that they provide a basis for all states, any state, anywhere in the world, to exercise criminal jurisdiction over the crime, regardless of where the crime was committed, regardless of the nationality of the perpetrator of the crime, or regardless of the nationality of the victim of the crime. Normally, under international law, states are only allowed to exercise jurisdiction over persons or transactions where they have some connection, right, to the person or the activity, classically that it took place on the state's own territory. International crimes, in contrast, are again, subject to what is known, what I've just described, subject to what is known as universal jurisdiction. Right. It's also the case that when states establish an international tribunal, right, the kinds of serious violations of international law that I've described are the kinds of crimes that can be made the subject of the jurisdiction of that international tribunal or that international criminal court. Right. So let's quickly review what some of the actual core international crimes are. What are some of these serious violations of international humanitarian law? The first is the crime of genocide. And we see in Article 1 of the 1948 Genocide Convention that the parties to the Genocide Convention specifically agreed that genocide is a crime under international law. Not necessarily the crime of the domestic jurisdiction, right, of the different parties, but it is a crime under international law, and they would undertake to prevent or punish it. What exactly is genocide? You see the definition here in Article 2 of the offense. Essentially, it's a series of very, very harmful acts involving killing or serious bodily harm when perpetrated against a national, ethnical, that's not a typographical error, that's the way it's framed in the convention, basically a national, ethnic, racial, or religious group as such, when it's committed with the intent to destroy that group. Genocide comes from the Latin of the side, the killing of the genus, of the type. So that's the essence of what genocide is. It is serious crimes committed with the intention to destroy a group. Right? The desire to eradicate a political group or a social group would not qualify as genocide. The widespread atrocities that were committed in Cambodia during the Khmer Rouge, right, which was largely, again, class-based, perpetrated by the Khmer Rouge against educated people, urban people, despite the staggering number of people killed, was not genocide, because folks were not killed on the basis of their nationality, their ethnicity, their race, or their religious identity. Okay. Again, those are the two keys of genocide, that it is directed against a group and that is perpetrated with the intent to destroy that group in whole or in substantial part. The second core international crime, serious violation of international humanitarian law, is what is known as crimes against humanity. Now, crimes against humanity is different from genocide in the sense that, at least as of today, it is not defined by treaty. Crimes against humanity is a kind of law that exists under international law that's known as customary international law. Again, this involves more foundations of international law and how international law is made. But if states engage in widespread and consistent practice, and if that practice is informed by a sense that the behavior is legally required, it can give rise to customary international law, of a different type of international law. And so there's not a single definition that parties have agreed upon in a treaty so far. There are negotiations underway. I expect in the next 4 to 5 years, we will conclude a convention defining crimes against humanity. But right now, I can only offer you what I consider to be a definition of crimes against humanity. And they are, again, a series of very serious inhumane acts: murder, extermination, torture, rape, enslavement, persecution, etc., which are perpetrated as part of a widespread or systematic attack against a civilian population. This is the essence of a crime against humanity, is that it is an attack directed against a civilian population. It can be carried out through different means. What's the difference between genocide and a crime against humanity? A crime against humanity might not necessarily be motivated by the desire to destroy a group in whole or in substantial part. There might be a desire to cleanse people from a certain area, or simply to eliminate them in a particular region because you want to control the territory. In other words, the intent to destroy the group in whole or substantial part is not required for a crime against humanity. Again, if you want to drive all the civilians out of a particular area, that would probably not amount to genocide. It probably would constitute a crime against humanity. This was a big issue for many years in the context of the conflict in Darfur, right? Where there were debates about what the Sudanese government, when it was launching attacks against civilians, was it again simply because it was trying to take control of territory and it wanted to drive civilians out so that it could maintain control, or was there a desire to destroy certain minority groups in Darfur? So this is, it was also a disputed or contested issue in Bosnia. Much of the violence that occurred during the civil war in Bosnia, at least the International Court of Justice has concluded, did not amount to genocide. The court was not satisfied that there was sufficient evidence of the intent to destroy Bosnian Muslims or Bosnian Croats in whole or in part. With respect to the actions that took place in Srebrenica in 1995, however, multiple courts have concluded that that did reflect actions intended with the intent to destroy a group in whole or substantial part. So this evidentiary issue and how you would ascertain what the intent of the actors is can be very complicated. So that's the second principle, international crime. Third is war crimes or violations of the laws or customs of war. And here we're using war in the sense of violation of the rules of war, right? The rules that regulate the conduct of warfare. By the way, neither crimes against humanity nor genocide require the existence of a state of armed conflict. As I said, that's why it's a bit of a misnomer to refer to this category of offenses as war crimes. A crime against humanity could be committed in peacetime. Genocide, or not in peacetime, but not in the state of an armed conflict between two armed groups. A government force could simply carry out genocidal action or could carry out crimes against humanity, even if a state of warfare does not exist. Right. So that's why the term is a little bit of a misnomer. In contrast, war crimes do take place in the context of armed conflicts. And the point of departure for war crimes go back to, again, there's old customary international law that goes back to, you can find references to, acts that are considered to be war crimes. If you read Henry V, back in Shakespeare's day, the decision by the British forces to kill their captives in response to a surprise attack by the French forces during Henry's battles there. And we see some of the commentators describing this as knavish or wrongful conduct. But really today, we would trace the notion of war crimes to the 1949 Geneva Conventions. These are conventions adopted after World War II, which are principally focused on protecting vulnerable persons and persons not taking place in armed conflict, right? Each of the four Geneva Conventions of 1949 defines a particular class of protected persons. The first Geneva Convention covers sick and wounded soldiers in the field. The second convention covers sick, wounded, and shipwrecked sailors at sea. The third convention covers prisoners of war. And the fourth convention covers civilians, these civilians who are in occupied territory or who find themselves in the hands of the enemy party. And then each of the nine, so these are protected persons. Each convention has its own class of protected persons. And then each convention says it is a grave breach to engage in certain actions against persons protected by the convention. And so we see that killing, torture, inhumane treatment, etc., is a grave breach. And then the conventions go on and impose an obligation on states to prosecute persons who have committed grave breaches. Now, I want to stress this is not protected persons, again, are persons who are no longer taking part in hostilities, right? They're vulnerable persons, right, who are no longer fighting, right? Again, civilians, POWs, sick and wounded soldiers and sailors. I should note here that these grave breach provisions are understood, at least when the conventions were adopted, as applying only in the context of interstate wars, only in the context of international armed conflicts. And that, of course, is one of the gaps or one of the problems in international law. Most of the wars that we've seen since 1945, in fact, have been civil wars, non-international armed conflicts taking place within the territory of a single state. Now, in addition to these grave breach provisions of the 1949 conventions, there are some older provisions of the law of war, what we refer to as Hague Law, based on the 1907 Hague Convention, that are now considered to be war crimes. Acts such as the use of poisonous weapons, wanton destruction of cities not justified by military necessity, attacks on undefended towns and villages, the willful destruction of religious, charitable, or educational institutions, plunder. These were different acts that were prohibited during wartime, and they were not only prohibited, but now we understand that they can give rise to individual criminal responsibility. There are many other rules of war that prohibit what states may or may not do, but not all of them, again, give rise to individual criminal responsibility. And then more recently, in 1977, the International Community of States negotiated a couple of protocols that are additional to the 1949 Geneva Conventions, the so-called 1977 additional protocols. And these involved a significant updating of the restrictions on what kind of conduct was permissible in wartime, focused not only on the treatment of vulnerable persons like prisoners of war or wounded soldiers, but adopted stricter rules on the conduct of warfare itself. And now some of the violations of those rules of warfare are also considered to be international crimes. They're grave breaches of additional Protocol 1 itself. Of attack, in other words, directly attacking civilians, is now prohibited under international law. And if you're a state party to the additional protocol, it's a war crime for one of your commanders or nationals to do it. Knowingly launching indiscriminate attacks, the perfidious use of the Red Cross, right? Pretending to be a hospital or a humanitarian and using that as a basis to launch attacks, right? It's like the false waving of the white flag to induce the other side to think that they're no longer to be attacked, and then dropping your flag and shooting. These are forms of perfidy, which give rise to individual international criminal responsibility. Something that's very significant, often sharply debated or discussed in the context of the Israeli-Palestinian conflict, the transfer of population into occupied territories, or the forcible deportation of people from occupied territories, is considered to be an international crime under additional Protocol 1. Apartheid and other degrading practices based on race, and then again, targeting clearly recognized historical monuments, works of art, or places of worship that constitute the cultural or spiritual heritage of peoples. These things are all war crimes.
I hate to interrupt, but what you're saying, it sounds like the destruction of Dresden, destruction of Hamburg, destruction of London during World War II would now be considered war crimes.
So the question is, what you're telling me, what you're saying is that the destruction of Hamburg, the destruction of Dresden, the destruction of Tokyo during World War II would be war crimes. And the answer is yes, they would be. Those were indiscriminate attacks. Those were attacks on civilian objects. In fact, a colleague of mine, Scott Sagan, who writes a lot on nuclear weapons, he and I published a piece a couple of years ago on whether the nuclear attacks against Hiroshima would be war crimes today. And our conclusion is that they would be. That's correct. These are indiscriminate attacks, not capable of distinguishing between. One of the basic rules of war now is that you may direct your military objectives only against military targets, not against civilian population or civilian objects. And if you launch a kind of attack which is incapable of discriminating or distinguishing between military objectives and civilians, that's an indiscriminate attack. And yes, if you are a party to Protocol 1, the United States, I should note, is not a party to Protocol 1, although we do accept the basic rule of distinguishing that you're not allowed to attack civilians and you're not allowed to launch indiscriminate attacks. But yes, it would be a war crime. That's correct. Okay. Again, this situation regarding war crimes, as I already adverted to, with respect to non-international armed conflicts, is complicated. Again, it's also unlawful in non-international armed conflicts to intentionally kill civilians. International law rules do reach some aspects in a limited way of the conduct of non-international armed conflicts, what we lawyers call NIACs, right? So there's a case where there's a prohibition, but there is not yet a general agreement as there is in Protocol 1 or in the Geneva Conventions of 1949, that violating that rule gives rise to individual criminal responsibility. And so most international lawyers would say there is no duty to prosecute those kinds of crimes, intentional killing of civilians, indiscriminate attacks, if they occur during a non-international armed conflict, if they occur during a civil war. Now, of course, states could adopt domestic law to make those things a crime, and more states could enter into another treaty in which they agree amongst themselves to treat these kinds of crimes, even when they occur in non-international armed conflicts, as criminal acts. And they could agree amongst themselves to prosecute those acts. And this is what states have in fact done, at least those states that are parties to the Rome Statute of the International Criminal Court. Talk a little bit more about the Rome Statute in just a moment, but the Rome Statute confers jurisdiction on the court over the crime of genocide. It confers jurisdiction on the court over the crime of crimes against humanity. And it confers jurisdiction of the court on war crimes. And there's a long list of specific crimes that could be committed in the context of non-international armed conflicts that states have agreed will fall within the jurisdiction of the international court. So even though these violations are not, as a general matter of international law, international crimes, and they don't give rise to, again, what I referred to before as universal jurisdiction, states could amongst themselves nevertheless agree that if one of their nationals has committed such a crime, or if it occurs on their territory, that they will treat it as an international crime. Okay, and then the last crime, the last substantive crime, perhaps I should have begun with this. This is considered to be in some ways the most important crime, or the crime of crimes, of international crimes, that is an international crime, is the crime of aggression, right? A crime against peace. The waging of aggressive war, using force in violation of the prohibition on the use of force in international law. And of course, the crime of waging aggressive war was the main criminal charge at the Nuremberg Tribunal. It took a long time after even the parties were able to negotiate the Rome Statute of the International Criminal Court to reach agreement on the crime of aggression. But today there is an agreement on the crime of aggression, and it is also one of the crimes that falls within the jurisdiction of the ICC. We see that it's the planning, the preparation, initiation, et cetera, of an act of aggression, which by its character, gravity, and scale constitutes a manifest violation of the United Nations Charter. There's a lot of debate about this because there are circumstances in which states maybe use force in circumstances where it's contested or debated about whether the use of force was lawful under the UN Charter. Is it lawful to use force before you've been attacked, for instance, if you anticipate that you're about to be subjected to an imminent attack, as Israel did in 1967 during the Six-Day War? Well, there are many who believe that that would be a violation of the United Nations Charter. And so this is why we see that the crime of aggression in the ICC and the Rome Statute is limited to those acts of aggression which are a manifest violation of the Charter. I think intended to take away gray area cases. The U.S. use of force against the Federal Republic of Yugoslavia in connection with the effort to stop atrocity against Kosovar Albanians in 1999 I mean, I think most honest international lawyers would say it was a violation of international law. It was a violation of the prohibition on the use of force, right? And this was the kind of thing that created great reluctance to reach agreement on a crime of a definition of aggression. If force is used for humanitarian purposes to aid people, will that give rise to individual criminal responsibility for the perpetrator? So this is the compromise definition that was reached in Rome, actually in Kampala, for the Rome Statute. Okay. Let me turn now to the second main thing that I want to talk about, which is how can these crimes be prosecuted? Where can they be prosecuted? And I guess I'll say, stop my share for a while. The international violations we've covered are international crimes, but the question of where they can be prosecuted, which tribunals might have jurisdiction, is separate from the question of whether they are international crimes. Again, the fact that they're international crimes means, as we'll see, they're subject to universal jurisdiction, and any state could prosecute a violator of these offenses. But the consent-based system I've described, when I described international law very generally at the beginning, the consent-based system I've described means that there is no international criminal court with universal jurisdiction over all violations of international humanitarian law, no matter where they occur, right? The closest that we have is the International Criminal Court, which I've already referred to, which is now located in The Hague, constituted pursuant to the Rome Statute, which was negotiated in 1999. There are 123 parties to the Rome Statute. So about 2/3 of the states in the international system are parties to the Rome Statute, but that means that 1/3 are not and have not accepted the jurisdiction of the court. The International Criminal Court has jurisdiction over the offenses that I've just described, but not anywhere in the world, or not committed by anyone in the world, right? Rather, the court has jurisdiction in two circumstances. Number one, if a crime is committed on the territory of a state party, or if the crime is committed by a national of the state party. The United States, of course, as we all know, is not a party to the statute, the Rome Statute of the International Court. The United States does not accept the jurisdiction of the court, and we would not accept the notion that our nationals could be tried for committing war crimes by the ICC. In the context of Russia's invasion of Ukraine, which of course is top of mind for many people when we think about the subject of war crimes, neither Russia nor Ukraine are parties to the Rome Statute of the International Criminal Court. Now, nevertheless, notwithstanding that, and notwithstanding the general rule that you have to be a party to the statute, Ukraine has availed itself of a provision of the Rome Statute which allows states to consent to the jurisdiction of the court with respect to a particular crime, right? That state may, by declaration, accept the jurisdiction of the court with respect to the crime in question. And actually, Ukraine, not even recently, but going back to the initial Russian invasion of Crimea in 2014, Crimea has issued declarations accepting the jurisdiction of the International Criminal Court, which means that Russian officials who are responsible for crimes committed on Ukrainian territory could in principle be held responsible before the International Criminal Court. Now, I need to caution, though, that this power of the court to exercise jurisdiction over non-parties when a state has issued one of these declarations accepting the jurisdiction of the court does not apply. It applies to the crime of genocide, it applies to war crimes, it applies to crimes against humanity, but it does not apply to the crime of aggression. Just one of the idiosyncratic bargains, right, that went into the negotiations leading to the Rome Statute. It was accepted that it would not be possible ever to prosecute the nationals of a state that is not a party to the Rome Statute for aggression. Again, I think this is a reflection of some of the anxiety or suspicion or fears about what might be a potentially too expansive role on the view that states had that the ICC could potentially have too expansive a role in regulating the recourse to force itself, as opposed to the means by which warfare was conducted. And so since Russia is not a party to the Rome Statute of the ICC, the court does not have the power to investigate or prosecute Putin or any other senior Russian leaders for the decision to launch an aggressive war, to perpetrate, to commit the act of aggression by invading Ukraine. But there is no such limitation with respect to the other crimes involved in the conduct of the war that are taking place on Ukrainian territory. Again, war crimes, possibly crimes against humanity. The Secretary of State of the United States, no, the Vice President recently declared that we believe that some of the Russian actions in Ukraine do constitute crimes against humanity. And so war crimes and crimes against humanity would fall within the jurisdiction of the ICC if those acts have been perpetrated, have been committed on Ukrainian territory. The ICC, I know, is working carefully and deliberately investigating these cases. I mean, I will say that proving responsibility for international war crimes is a difficult and a challenging matter. I worked very closely with the Yugoslavia War Crimes Tribunal in my last assignment in the US government. I was the legal counselor at the US Embassy in the Netherlands, worked very, very closely with the Yugoslavia War Crimes Tribunal, which was investigating crimes committed in the context of the civil war in the former Yugoslavia. And I would often hear somebody tell me that, well, everybody knows that Momcilo Krajisnik or Radovan Karadzic or Slobodan Milosevic have committed war crimes. But it turns out there's a significant gap to cover between everybody knows, based on what we read in the paper, and what you can prove beyond a reasonable doubt in a court of law. And the evidentiary challenges here are severe. And so I believe that the International Criminal Court is working diligently to try to establish. We know that war crimes have been committed and crimes against humanity have been committed in Ukraine. The question is establishing who is responsible for them, who had command responsibility, who ordered those acts, who had control over the relevant units. I do expect that we will see indictments before very long issued by the International Criminal Court for Russian military leaders and possibly perhaps certain Russian civilian leaders for crimes committed in Ukraine. Whether or not it will be possible for the court to gain custody of individuals it may indict, of course, is though an entirely separate matter. The International Criminal Court has no police force. It cannot compel Russia to surrender its nationals to the ICC. And so one might think there's simply no chance that these individuals will ever see justice. And here I will just tell you a little anecdote. When I was working on the issues related to the Yugoslavia War Crimes Tribunal during my time in The Hague, Slobodan Milosevic was the president of the Federal Republic of Yugoslavia. He was an authoritarian leader, and he'd been indicted by the Yugoslavia War Crimes Tribunal. And everybody thought, well, of course, it's inconceivable that he would ever essentially turn himself over to the Yugoslavia War Crimes Tribunal. But time passes, Milosevic's political vicissitudes changed, right? He fell from power. And one of the last things that I did in my job in The Hague was to coordinate the S-4 flight that brought Slobodan Milosevic to the Netherlands, right, where he was brought into custody and where he was eventually put on trial before the International Criminal Tribunal. He committed suicide, as many of you know, before the court was able to render a judgment in his case. And so he cheated the hangman, if you will. There's no hangman in The Hague. There's no death penalty. But again, it reminds me that the time scale, there is no statute of limitations on these kinds of crimes. And whether Putin can be brought into custody today, of course, the answer is of course not, but there's a long future ahead. And so one can't know what to expect. All right, so that would be prosecution before the International Criminal Court. Another possible venue for prosecution for some of these crimes, at least, would be in domestic courts, in the national courts of different countries. So Ukraine, for instance, has jurisdiction over crimes that are committed on its territory. And last year, this is Vadim Shishimarin, a Russian army sergeant who pleaded guilty to fatally shooting an unarmed Ukrainian man in the earliest days of the war. A panel of judges in Kyiv found him guilty of violations of the laws of customs of war crimes, basically, and sentenced him to life in prison. There are likely to be many, many more prosecutions like this. We know that the Ukrainian prosecutors have a file of tens of thousands of cases, and they have captured many Russian soldiers as prisoners of war who can be prosecuted in Ukrainian courts for these offenses. And moreover, it's notable that it's also a crime under Ukrainian aggression. This is relatively unusual, but aggression is also a crime under domestic Ukrainian law. This is a legacy of World War II, when the Ukrainians experienced aggression at the hands of the Nazis, and they enacted a law making it a crime under domestic Ukrainian law to perpetrate aggression. I can imagine the possibility of senior Russian military officials being captured and tried for the crime of aggression in Ukrainian courts. Now, one footnote I should note here, there's a technical legal issue. This is the advanced version of the class. I can tell I'm dealing with a sophisticated audience, so I'm ready to go here and kind of go to the advanced version. There's another set of international law rules that basically referred to as foreign sovereign immunity rules that generally make it impossible for the courts of one country to sit in judgment of the acts of another country. And with respect to individuals, there are certain high-level officials who are deemed to be immune from the jurisdiction of the courts of another country. So head of state immunity is one example. It's generally understood that the head of state of a country can't be prosecuted for wrongful conduct in the courts of another country. And it's not only the head of state. There might be certain other senior officials. The International Court of Justice, in a case some years ago, indicated that a country's foreign minister, right, could not be prosecuted in the courts of another jurisdiction. But it's not all government officials, right? And so certainly many government officials, we don't know exactly where the line would be about who would be able to claim official immunity in the courts, foreign sovereign immunity in the courts of another state. But I imagine that there would certainly be some officials, including relatively senior officials, who could be subjected to prosecution, not the head of state, the minister of defense, maybe not, the foreign minister, probably not, the chief of defense, I don't know, the commander of the armed forces in Ukraine probably would not have that kind of immunity. So that's just a wrinkle. In addition to Ukrainian courts, again, remember I said before that what makes the acts that I've described in the talk today international crimes is they're subject to universal jurisdiction, which means that any state potentially could prosecute officials. And in fact, many countries, not the United States, but many countries have adopted laws that do make it a crime for a person who's committed one of these serious violations, rather, of international humanitarian law, crimes against humanity, war crimes, or genocide, no matter where those crimes occur, no matter what the nationality of the perpetrator, and no matter what the nationality of the victim, states have made that act a crime that can be prosecuted in the domestic courts of those countries. Again, this is the idea of universal jurisdiction. And so we could see, for instance, cases brought in European courts. We've seen examples of this. There have been cases involving prosecutions in Germany of Syrian officials who were implicated in torture in detention camps in Syria. There have been cases of mistreatment, again, torture cases brought against Afghan security officials in the Netherlands. A number of Rwandan cases were brought in Rwanda with respect to involvement in the genocide in Rwanda. So we could see prosecutions in the domestic courts of other countries. Once again, there will be a challenge of how the courts in France or Germany, the Netherlands will gain custody of these officials. But it certainly at a minimum means Russian officials who might have been involved in planning, taking part in these activities are going to be very reluctant, or should be very reluctant, to travel outside Russia, not only because the state to which they travel might have a universal jurisdiction law, but it might have an extradition relationship with a country that does. So I think that will be one implication of this. And then finally, there's been talk, and I'll just finish with this. There's been some talk because there's frustration about the fact that the International Criminal Court is not open to prosecution, for crime of aggression, and that President Putin could not be tried in the domestic court under head of state immunity. There's a feeling that there must be accountability for the crime of crimes, aggression, and that the most senior leaders should be subject to criminal accountability for their actions. So there has been talk about setting up an international or an internationalized court. And there are a couple of different ways this could be done. I know there's a lot of discussion among non-governmental organizations and some I know within the European Union and some other diplomatic fora. There's quite amount of thinking and discussion about this right now. A multilateral treaty could be negotiated between Ukraine and certain other states to establish an international criminal tribunal with jurisdiction over the crimes committed in Ukraine. I mean, after all, the court that conducted the trials, the Nuremberg trials after World War II, was established pursuant to a treaty, right, between the four victorious powers, France, the US, Russia, and the UK, right, after World War II. So that would be one means by which such a court could be established. We could Ukraine, United Nations, where that authorization was made not pursuant to the Security Council. We talked about the fact that the Russians would prevent activity from being, decisions from being taken by the Security Council. But the General Assembly probably has the authority to authorize the United Nations to enter into an agreement with Ukraine for the establishment of such an international tribunal. In fact, a special court was established many, many years after the events that I referred to in Cambodia. The extraordinary chambers in the courts of Cambodia, an internationalized court was established to prosecute certain war crimes for a small number of surviving Khmer Rouge officials. And it was established pursuant to this kind of agreement between Cambodia and the United Nations in response to a General Assembly authorization. And it would be, there would be little doubt that there would be the votes to establish such, there would be support for this in the General Assembly if the modalities were arranged. And then there could be some kind of hybrid court established within a specialized court within the domestic legal system of Ukraine, but perhaps with the participation of international prosecutors or international judges. This kind of hybrid court model has also been something that we've seen was established for a special court that was established for Sierra Leone, for example, as a way of bringing international expertise and an international imprimatur to the prosecution. And at least the first two kinds of courts, one established pursuant to a multilateral treaty or one established pursuant to an agreement between the United Nations and Ukraine, would overcome this problem of head of state immunity, because head of state immunity applies only to the immunity of a head of state of one country in the courts of another. It's accepted that there is no head of state immunity before international courts. Right? So heads of state like Charles Taylor have been prosecuted before the special court for Sierra Leone. Slobodan Milosevic was prosecuted before the International Criminal Tribunal. So a properly constituted international court would be able to exercise jurisdiction over a head of state without concern about head of state immunity principles. Let me stop there and now turn it over to you for your comments or questions. I'd be very happy to try to answer such questions as I might be able to, or listen to your reactions.
That was terrific, Alan. Thank you. I think I'll let you field questions within the room yourself, but after a couple in the room, we should go to the Zoom folks.
Absolutely. All right. So in the law school, you know, I cold call people if they don't have questions. It creates a great deal of anxiety on the part of my students. I prefer not to do that. So if you do have a question, feel free to ask.
I'll start.
Tom.
What conventions is the United States a party to? Which ones are we not? And why are we not a party to all of these?
Conventions with respect to the underlying rules or the venue in which the courts might, the cases might.
Both.
Okay. So with respect to the treaties governing the conduct of warfare itself, the United States is the party to the 1907 Hague Convention. We are a party to the 1949 Geneva Conventions. We are a party to the Genocide Convention of 1948. We are not a party to the 1977 additional protocols. There are two protocols, additional protocol 1, which was designed to elaborate the rules, the restrictions on the conduct of warfare that applied in international armed conflict, conflict between states, and Protocol 2, which applies to armed conflict taking place within a country, although it's no longer within a country. We used to think of non-international armed conflicts as civil wars. Wars taking place, within Colombia, for instance, right? But there's been a new kind of conflict that has emerged since 9/11 for the United States, which is conflict between a state on the one hand and a non-state group on the other, like Al-Qaeda or ISIS. But it's not a civil war in the sense that it's not taking place within the territory of the United States. So we refer to these as non-international armed conflicts or non-interstate armed conflicts. In any event, the United States is not a party to either of the additional protocols. The United States likes the rules for the most part in additional, except for some provisions that dealt with how the law of war would apply to the non-international armed conflicts that were all the rage in the 1970s. Which were the wars of colonial liberation. And because of the power of the global South, there are provisions in additional Protocol 1 that will allow wars of colonial liberation to basically be treated as international armed conflicts, which in fact would confer certain war rights on those people fighting a war of colonial liberation. Whereas in the United States and other places in the West, we would see such people as terrorists, right? Non-state fighters. So that's why the United States objects to Protocol 1. Protocol 2, we actually have no particular objection to, but it's always been the tail to the Protocol 1 dog. And without being able to move Protocol 1 through the Senate, there's not been enough appetite to just try to ratify Protocol 2 by itself. In terms of the courts, yeah, the United States has grown. The United States was a big champion right after World War II of the notion of the creation of a global international legal system that would be governed by the rule of law. And we still rhetorically talk about our commitment to a rules-based order. I will say sometimes we don't walk the walk in the way that we talk the talk. So, for instance, the United States no longer accepts the jurisdiction of the International Court of Justice. That's not a criminal court. It's effectively the equivalent of a civil court in which countries sue one another over violations of international law. The United States, after we lost the Nicaragua case in the 1980s, we said we no longer accept the jurisdiction of the International Court of Justice because we really did not. Either we think that their decisions were really terrible, or we wanted to engage in conduct that was skeptical or doubtful or dubious from an international law matter. And we don't accept the jurisdiction of the International Criminal Court. We do not believe that an independent prosecutor should be holding U.S. personnel responsible for the commission of alleged international crimes. We say that that is true because we believe that our own domestic legal system, right, will ensure that any U.S. soldier, our military code of justice will ensure that any U.S. soldiers who commit crimes will be held responsible. And that is often true, but it's not always true. And I think there are allegations, for instance, of quite widespread abuses by the United States, both military personnel and non-military personnel who are not covered by the Uniform Code of Military Justice from the intelligence community who committed mistreatment, who abused detainees in Afghanistan and in Iraq and elsewhere, and they have not been held accountable criminally. So, so that's why the United States is reluctant. And then we have a question here.
I was kind of concerned about the treatment of prisoners and whether in a war situation that's an aggressive conflict, that they the perpetrators would think it's mercy killing to just, not to treat injuries or go to the trouble to feed prisoners, whether that's just basically what war is like, but I don't know. There was one part of the first convention that said taking children from their homes and giving them to another.
You speak into the mic, Peter.
There was one convention, from convention one, there was something there about taking the children of the people who's part of the genocide. Take the children of the people and take them into another population that was the enemy's population. One of the that's currently reported in Russia. I don't know if that's something that can be enforced on the international court.
Yeah, so just to repeat for those listening home, one question is, do we really expect soldiers waging war to do anything but engage in mercy killing? Isn't that really what war is about? And do we really require them to care for the wounded and the sick in the field? And the second question concerned it referred to a provision of the Genocide Convention, which basically one means of perpetrating genocide by one means of destroying a group of people is to basically kind of take all of their children away from them, right? And so on the first question, I think the answer is, in wartime we do expect, or we certainly look, the whole notion of international humanitarian law is not to prevent war. We recognize that war is going to happen, but try to eliminate some of the most severe inhumanities of war, right? And I think that, yes, the expectation is now quite clearly that wounded soldiers, must be cared for. It was quite interesting. I have a colleague at Stanford who's a doctor who does Paul Weiss in the medical school faculty there, who does a tremendous amount of amazing humanitarian work, and he talks about work that U.S.-based humanitarians did who were embedded with Iraqi forces that were engaged in the liberation of Mosul. And not only did they have a duty to treat ISIS fighters, but they had to do it on a non-discriminatory basis. In other words, they couldn't say, we'll treat the Iraqi forces with whom we're embedded first, and then the ISIS fighters later. We have to basically use triage techniques, and we treat the most severely injured combatant we can save without regard to nationality. That is the essence of humanitarianism that is embedded in it. Is it honored with perfect fidelity? Of course not. I think war is terribly, barbaric, but yeah, if we see people who are killed with their hands tied behind their back, that's a war crime. And in fact, the first evidence of war crimes that we saw, reported from Bucha in Ukraine involved exactly that, right? And that was what we saw at Srebrenica with the killing of men and boys, is people who were killed with their hands tied behind their back. That is essentially a per se war crime, right? That is someone who is by definition no longer taking active part in hostilities. And with respect to the second offense, yeah, I think in occupied territory, you have duties with respect to the treatment of the civilian population, and certainly removing part of the population, children or otherwise, would be a grave breach of Protocol 1, and would be something over which the International Criminal Court would have jurisdiction. Yes.
Look at counsel.
Hi, thanks for your talk. My concern is that, okay, you've got what you put up on the screen in any case, the genocide rules list groups that you cannot
Destroy in whole or in substantial part.
The crimes against humanity has a different set of populations that you cannot act against. Are those strictly held that if genocide is against a gender, even though gender wasn't listed there, then it's okay? But it's a crime against humanity only, for those groups that are listed on the page.
I mean,
And I'm asking partly because, there was also a list on the genocide about taking children away from one group and giving them to another group. Like the Aborigines in Australia, or like the Native Americans in America, or like the immigrants at the border, children taken away from families. And those, is that part of crimes against humanity, even though it was under the genocide list?
Okay, so the question is, there are two parts to the question. Number one is, if you intend to destroy a group, but it's not on one of those enumerated categories in the Genocide Convention, for instance, such as gender, right? Is that not genocide? And, is it okay? Or is it a crime against humanity? And then the second question again concerned the scope of this question of taking children away from their parents. Would that include the taking of indigenous people away in Canada or the United States, or the Aboriginals in Australia, or even taking children away from their parents at the border? On the first question, tell me your name.
Diane.
Diane, it's a great question. I have to confess, it triggers one of my international law pet peeves, because whenever mass atrocities, terrible, cruel, barbaric acts are taking place, invariably a group of incredibly smart international law experts get together and debate whether the conduct does or does not fall within the scope of the crime of genocide. And we see this even now with Ukraine. There are questions about whether a cultural genocide is being perpetrated, and does that fall within the definition of genocide? The implication being that if it's not genocide, like, you get a medal for it. And you don't. I mean, these acts are terrible, terrible crimes. They're international crimes, and they're subject to universal jurisdiction and can be prosecuted before international courts, but they may fall within the scope of a different crime. I mean, the definition of offenses in US law, it's the same thing. It's true. Like, did you commit robbery, or did you commit theft? It depends on whether certain elements of the offense, were met. And these are technical legal definitions. So yes, it's not possible to commit genocide against a gender. It's interesting. I mean, I've been on panels with a colleague of mine, Catherine McKinnon, who has made exactly, this argument that even domestic violence, that's systemic, and the number of women who are killed, right, and injured in domestic violence in so many societies is at a level of harm that it should be genocide, right? But maybe we should change the definition of the offense, but the definition of the offense is what states agreed to in 1948, and it hasn't been modified. The scope of the target population, in contrast, for crimes against humanity, is the civilian population. And that can be any segment of the civilian population, right? So I have been on panels asking whether the attacks, against the United States on 9/11, could those qualify as crimes against humanity? And I think there's a plausible argument that they could, because this was an attack against the civilian population of the United States. Widespread killing of women clearly would be a crime against humanity. So the fact that it might not amount to genocide, I guess, just doesn't necessarily mean that it's okay, would be the pushback that I would have. On the second question, it's considered, remember that the list, that's the kind of the enumerated list in the ways by which you could commit genocide in the convention are, I'm not driving this so well right now, but let's see if we have this here, right? Are basically meant to produce the destruction of that group in whole or in part, right? So taking the children away is a means of destroying that group. If there are no children, then the group can't replicate, right? And it will be the end of that people. It will be if all of the Aboriginal children are taken away, then that will result in the extermination of the Aboriginal people. And if that's the intent, right? Again, the crime it's a crime when it is committed with the intent to destroy, right, a group in whole or substantial part. If that act is done with that intention, it could be genocide. Now, of course, the treatment of the Native Americans in the Western Hemisphere, right, and the Aboriginals happened long before, right, the Genocide Convention was adopted. When the United States became a party to the Genocide Convention, by the way, we took a reservation in which we said explicitly, and this has nothing to do with anything that happened here with respect, to the Native American population. So it would only be perspective. The acts at the border, I mean, this would be the kind of things that lawyers would debate. Why are children being taken away? I think the fairest argument is children are being taken away to discourage people from coming to the border, not necessarily to destroy that ethnic or national or racial or religious group in whole or in part. But if you were a good lawyer and you could persuade a court that the children were being taken away to destroy that group in whole or substantial part, you could make out a case for genocide.
Lou, let's go to some of the questions you've received from Zoom.
Yes, we have a number of questions. Thank you for taking a break from the room. First question, have I understood correctly that a head of state can be held accountable after that person's term of office has passed?
That's a very advanced international law question. The short answer is one's automatic head of state immunity. There are two kinds of immunity. I'm not going to use the Latin phrases, but there are two kinds of immunity. There are status-based immunities and there are conduct-based immunities under international law. And so head of state immunity is a status-based immunity, and then that does disappear after the head of state leaves that role. Right? But it may be that the former head of state retains conduct-based immunity. So let's say that you entered into let's say that you sublet your apartment from the head of state. Like he had a real estate business on the side, right? And like he didn't repair the place and keep it up to good standards. While he's the head of state, while he's the head of, say, the head of state of like Macron, he's the head of state of France. I can't sue him in the US while he's the head of state, but after he leaves office, I can, right? Because his conduct for renting these apartments was not official acts immunity, right? With respect to his official actions, though, right, it would be the case that his behavior would remain outside the scope of the jurisdiction of another court. One of the areas around which there's a great deal of litigation and disagreement, and the law is evolving and not settled, is whether or not illegal activity, like launching an illegal war, right, which is a violation of these foundational principles, right, whether one retains official acts immunity for that. One view is that, well, maybe one does, but if you're a party to a treaty that prohibits that conduct, your state has waived that immunity. So that was the basis upon which General Pinochet actually was prosecuted, was indicted in Spanish courts as when he was a former head of state. So the short answer to that is it depends. One would want to look at a lot of different factors. What is the crime for which the former head of state is being charged? Has his country consented somehow to a jurisdiction for prosecution of that state? Might very well retain immunity in the domestic courts of other countries.
Hey, the next question. What can be done to put more teeth into war crimes prosecution, such as holding leaders accountable?
Well, that's the difficult question. I mean, if you accept my premise that international law is a consent-based system, then we need to all mobilize our governments to be more eager to push for, but also to accept accountability. And this has been the problem for the United States. We've been quite enthusiastic about supporting the creation of the International Criminal Court as a tribunal that would prosecute other people, but would not prosecute the United States. And I think many people, I am among them, believe that that undermines the credibility of our case. It really reaffirms the basic notion, the basic instinct that at some level, sovereign concerns will take priority over the interests of accountability. I think there has been a dramatic change. When I was a young lawyer in the State Department, one of the issues that came up on my agenda was what to do about the fact that the Salvadoran government was about to enact an amnesty at the end of the Salvadoran Civil War. And the US Embassy got advance notice that this was coming, and actually the government was saying, like, what are you guys, i.e. the Americans, going to think about this? And because I was a lawyer dealing with Latin American affairs, this came across my desk. And the first thing I did, because you do look at precedent, right? So I went and said, what did we do when they adopted an amnesty in Chile? What did we say in the US government when they adopted an amnesty in Argentina in the late 1970s after the episodes of mass atrocities or substantial violent crimes in those countries? And the US government in those days advised the host governments that how to deal with atrocities that had happened in those countries was a matter for the Chilean or the Argentinian people to decide. That's not true anymore. This issue, the question of accountability, is on the radar screen whenever these kinds of atrocities take place. Now, that is not, I don't want to, no one, even an international lawyer shouldn't be so naive, right, as to believe that that necessarily means we're going to see accountability for all these crimes in all instances. But this is a long-term, years-long, decades-long process, and the tide is ever turning in favor of greater accountability. And I think we can tell our elected legislators here in the United States that we believe that the United States should embrace the International Criminal Court as a way of modeling our commitment to international accountability for those who commit atrocities, and to demand that when our own leaders commit atrocities, when we authorize torture, as we did in the United States in the days after 9/11, that we hold ourselves accountable for that. And so maybe the most that we can do here in the United States, is to try to ensure that our political leader, that we encourage our political leaders to model the right behavior ourselves.
Take one more, Lou.
Can I ask one more?
Yes.
Okay, what changes do you foresee for these quote unquote protocols in the future? What crimes might be added? What wrinkles might be ironed out? What punishments might be handed down to a state that aren't used now? So looking to the future.
It's a great question. And so I haven't thought about this deeply, so I will tell you, I'll just give you a kind of an off-the-cuff reaction. I think we will see two kinds of crimes that maybe are likely to become more prominent. Number one, I think the awareness of environmental harm has become a much more, there are already rules that in the Geneva Conventions in Protocol 1 that prohibit intentional harm to the environment, but I can see expansion of those rules as we recognize increasingly the fragility of the environment. I think the other area, it won't be so much a question maybe defining new crimes, but I think what we're going to have to figure out is how do we deal with the status of new weapons that are informed by new technologies. So there's been a great deal of work to try to figure out when does a cyber operation, a hostile cyber operation, like the Colonial Pipeline attack, or a distributed denial of service attack that shuts down a country's computer, or a Stuxnet attack of the kind that we believe the Israelis, with the support of the United States, committed against. I have an Israeli colleague who says that every time in her classes in Israel, anybody makes a reference to Israel's nuclear weapons program, one of her students will say, like, according to foreign sources, right? Because they could never admit that they have a nuclear weapon. So I think figuring out how the law will apply to cyber operations, I think, is one of the great challenges. I think another great challenge will be to figure out how the law applies to laws, lethal autonomous weapons systems, right? Systems that are basically automated. And where in the chain do we hold individuals responsible? Is it the programmer who wrote bad code, right, and produced a drone that, you know, launched indiscriminate attacks? Was it the commander who didn't check what the code, you know, authorized and, you know, released that drone? So trying to figure out how these rules about the conduct of warfare will apply with increasing automation, I think, is going to be a great challenge.
Come back into the room. You still have a question? Yeah.
I'm thinking about 9/11, and I'm thinking about crimes against humanity, which all of the pilots of the planes committed, and of course were never brought to justice because they all killed themselves. It seems to me that the U.S. did take the law in its own hands in the killing of Osama bin Laden, but I'm just wondering if there was ever justice for the thousands that were killed in 9/11.
So, I mean, as a matter, the question is, you know, for those in Zoom, was there justice after 9/11, particularly taking into account that the 19 hijackers, you know, themselves killed themselves in the flight? So I would say, and Osama bin Laden was killed by U.S. forces summarily rather than in a courtroom. Now, I think if you go back and you look at the remarks that President Obama made at the time, I think he probably said justice has been done with respect to the killing of bin Laden. And so certainly that was a position that was articulated, that this was a kind of an eye for an eye justice. You know, we're in a Methodist church, we're in a New Testament church here. I come from an Old Testament kind of congregation where we do an eye for an eye, right? So that kind of justice. We also, you know, I think made a terrible, terrible mistake after 9/11 by deciding that we wanted to try to there are 5 individuals who are held at the U.S. U.S. Naval Station at Guantanamo. You know, Khalid Sheikh Mohammed and 4 others who are indicted as being among the key planners of the 9/11 attacks. And my own view is that we made a terrible mistake after 9/11 by deciding that we wanted to prosecute individuals linked to the so-called war against terror, our campaign against against Al-Qaeda and the Taliban and associated forces through these military commissions at Guantanamo, right? Rather than just putting them on trial in Article 3 federal courts in the United States. We have put other terrorism defendants on trial in U.S. courts, and you know, they've gone fine, right? Prosecution has a pretty good success ratio. People have been convicted. You know, the USS Cole bomber was tried in federal court, is, you know, serving a life sentence right now. But we decided, I think largely for symbolic reasons, that we did not want these defendants to have all of the rights of our civil courtroom. So we're going to try them in military commissions. It's been 20 years, and all of the legal nightmares associated with those commissions mean that KSM, Khalid Sheikh Mohammed, and his 4 co-defendants still have not been tried. They're still in pretrial custody. They've been detained like for all these years, awaiting their military commission to start. So if that military commission could ever do its work, I suppose we would have a trial, which would involve the presentation of evidence and a verdict, and perhaps that would provide some sense of justice. But I think it's kind of an own goal here that we've inflicted upon ourselves by deciding to carry out these trials in military commissions.
Is there another question in the room? Robert, did you?
Oh, can you hear me? Okay, I want to talk about both what I call the wars of Yugoslavian secession and also the civil war in Nigeria, I guess 50 years ago, because in these cases there were nations that had declared themselves to be independent, Biafra in Nigeria, and then Bosnia, Croatia,
Slovenia, Macedonia, Montenegro.
All the wars, but they weren't necessarily recognized.
Yeah.
You talked about how we have international wars versus civil wars. It seems to me there's a bit of a conundrum here because you have different perspectives. Is this a civil war? Or is this an international war?
So that's a really profound question. And we see it today, right? Because in the context of the Russia invasion of Ukraine.
Could you please repeat the question?
Yes, I'll repeat the question is, I drew a distinction, the questioner noted that I drew a distinction between international armed conflicts on the one hand and non-international armed conflicts. And the question is, how does that work in the context of a secessionist struggle where an entity claims that it is now its own state? And is such a circumstance an international armed conflict between the new state and the rump state, or is it a non-international armed conflict? What standards do we have to deal with that? And I think that's a really profound question. And I was simply beginning by saying we have that issue presented in Ukraine today, because the LPR, the Luhansk People's Republic, and the DPR, the Donetsk People's Republic, right? 2 entities in the Donbass have declared themselves to be independent states. And Russia has recognized them, right? And says, in fact, part of our legal basis for waging war against Ukraine is to come to the aid of these states, just as the United States came to the aid of Kuwait in 1990, right? Northern Cyprus is another example of this. And I think the answer is, there are standards under international law for determining when an entity qualifies as a state. There are a series of criteria that have to be met. And then we also look at the end largely at the question of whether or not an entity is recognized as a state. And the short answer is that Biafra was never recognized as a state, right? But when the European Union recognized and the United States recognized Bosnia and Croatia as states, that changed the legal character of that conflict. Nobody has recognized Abkhazia, and South Ossetia and the LPR and the DPR as states. So simply saying that they're states does not make it so. We first try to look objectively at whether they meet the requirements of statehood. Do they have a population? Do they have territory? Do they have a government that's able to exercise control over that territory without external assistance? Do they have this habitual support of the population, right? Those are among the legal tests that we would look at. And because there can be disagreements about that, at the end of the day, we look largely at the question of whether or not they're recognized by the rest of the international community. The hardest borderline case, and then the way that we really know whether they're recognized is whether they get admitted to the United Nations. The real borderline case, the grayest area case, has been Kosovo, right? Which a lot of international lawyers can debate. You have a follow-up?
Yeah, real quick one. What about? Yes, I do have a follow-up. What about Taiwan versus mainland China?
Yeah, great follow-up question. What about Taiwan versus mainland China? if Taiwan were to declare itself to be an independent state, I think it would quite clearly meet the international law standards. It has its territory, it has a population, it has a government that exercises control that is habitually obeyed, it conducts foreign relations, it negotiates international treaties, right? Whether it would be recognized and by whom would be, we would have to see. What prevents us from having war in the Taiwan Straits is that Taiwan does not declare itself to be an independent state. Taiwan and the mainland both agree that there is one China, and Taiwan is a part of it. And there's simply a disagreement about who's in charge of it, who the government is. But yeah, so we don't have to reach the question. This is a question I ask myself. I ask my students. I talk about the Libya conflict. What if the folks in Benghazi had said, "We're not claiming to be the government of Libya. We're now claiming to be the government of a new state called Eastern Libya," right? Would they have met the standards of statehood? Maybe. But for right now, we don't have to face that question in Taiwan because there has been no claim of statehood.
We have reached the end of the allotted time. Alan, thank you for a terrific presentation.
Well, thanks to you for coming out. I really commend you for coming out on a Sunday evening and for your interest in these questions and your engagement with these themes. And I will say the one difference between you is when I refer to things like the Civil Wars in Nicaragua or El Salvador, I look around this audience and most of you nod with recognition. My students have no idea what those things are. So thank you for being an engaged and attentive audience.
And I want to close with a question that I believe is the short answer. And that to pick up on the point of the wheel of history is turning in the direction of greater accountability for individual action. That within my lifetime, which begins before the Nuremberg trial, much of what you've discussed tonight has become a part of international law. That we're moving in the right direction, even though it's often extremely difficult to implement, to act, to convict. Is this judgment too optimistic?
So for those listening at home, Tom's question is, he has the perception that we are perhaps gradually moving in the direction of greater accountability for these kinds of atrocities, holding people responsible for prohibiting the worst kinds of abuses and warfare and holding people accountable for those acts is a phenomenon that really is relatively new since World War II, and that we're moving in the right direction. And he asks whether that perception is too optimistic. And my answer would be no, Tom, I share your view. Again, when the Kaiser, there was efforts after World War I to talk about trying the Kaiser, but they thought they couldn't because he hadn't violated international law. There was talk about putting him on trial for crimes against morality, right? But there was no notion that he could be held criminally responsible for the abuses that he perpetrated or ordered. And so, yes, I think it is, you are correct to be optimistic, but we must be guardedly optimistic. And I always am reminded of the old proverb when I think about the path of international justice, that the ox is slow, but the earth is patient.
Thank you, Alan. A reminder that next week's topic is economic warfare, and the speaker will be me. So I hope to see all of you back. Let your friends know, and a reminder that this is being recorded and will be available on the Great Decisions website for the church in another day or two. So thank you all, and thank you, Alan.
Thank you so much. It was great.